level of scrutiny higher than the rational basis test.
But so far, the U.S. Supreme Court has used the rational basis test, right? In the Romer v. Evans case, that's the big case on equal protection and gay rights.
Yes, this is true, Your Honor, but we're going to present an argument. This issue has come up many times already, whether or not the gay marriage should be comparable to those cases dealing with interracial marriage, and that issue will be addressed in one of our arguments.
That Proposition 8 does not even meet the rational basis scrutiny test established in the case of the United States versus Carolyn Insurance Company, and that the alternative to same-sex marriage that is offered in California, the domestic partnership, does not provide a suitable substitute for marriage. First, on the point that homosexual citizens should be classified using a level of scrutiny higher than the rational basis test. In the case of Loving versus Virginia, Mildred Jeter, a black woman, and Richard Loving, a white man, had been found guilty of violating Virginia's ban on interracial marriage and were ordered to leave the state. The court found Virginia's law to violate the Equal Protection Clause because it individually classified on the basis of race.
So what do you say to the arguments made by your opponents earlier that there's that race and the history of slavery were the causes of the Civil War amendments, the 14th Amendment, and the Equal Protection Clause in particular, that really the whole apparatus of racism over time is simply not comparable to what you're talking about here, particularly if a state grants civil union?
I will address how it correlates to interracial marriage. Also, one of the things that is so important about solving this gay marriage, problem is that what happened with, interracial marriage and all that, it got into such a, big heated debate. It would be really great, I think, if the country could find a solution on this before it became, a matter of much more serious civil rights cases. War.
Do you think the court order from us is the solution?
I do believe it's a step in the correct direction.
Well, what about, as my colleague mentioned earlier, the Roe v. Wade precedent? Sometimes when the court steps in, it doesn't end up being a catalyst for settlement or bringing people together. It just inflames things further, and then we've got decades of very polarized politics. This situation is kind of a recipe for that, isn't it?
It's different for every case, obviously, but we believe that in this case, similar to the case of Brown versus Board of Education, that it would be a catalyst. But more than that, it seems to me that it's one of the reasons why the court has been refusing to speak on this case because the public may not be ready. But
is that a legitimate thing for a court to think about? The readiness of the public or public opinion, or should that be ruled out of the legal analysis of what the Constitution means?
In Roe v. Wade, even though the public wasn't ready for it, it doesn't mean that it wasn't the correct thing to do. And even though people may not be ready for it, the time for doing the right thing shouldn't be put off until a later date where maybe we might be able to take it. You should always do the right thing whenever you think that liberty is being taken away from you.
Should a court worry about its ability to protect liberty more generally by jeopardizing its own legitimacy by really walking out far ahead of public opinion? Is that something the court should be self-consciously thinking about? If we take on public opinion at a point like this, we may lose our capital, in a sense, our political capital to be able to protect liberty across the board.
One example of how the Supreme Court actually took that into consideration in actual application was Brown versus Board of Education. They stated that the integration of both
one more point is that, I believe the point of contention here is if the Supreme Court were to rule on this issue, would they lose all their public support and theoretically all their power? And I don't believe that the American people would be willing to lose complete faith in the Supreme Court over this issue, because that would lead to, a lot of instability and, could even theoretically lead to a very large imbalance of power, and that would that could theoretically destroy our nation.
Well, I'm glad that you believe that, and I hope other people believe it, but we already have your opposing counsel up here today telling us it would be activists of us, which is a very charged term. And we can look back